Impact of Influence.
Covering true crime throughout the Southeast.
Hello, friend. Matt Harris, Seton Tucker here, and so grateful that you're going to spend time with us. Always appreciate that. We're talking about the Michael Colucci trial in just a few minutes. But first, Seton, how can they get in on the conversation?
You can find us on Facebook at Impact of Influence and also our YouTube channel.
Now, YouTube, when you get there, hit that subscribe button. That's very important. The last episode was really rushed, so we didn't get it up on YouTube. This one will be. That's a guarantee. We're part of the Evergreen Podcast Company, and we would hope that you'd support our sponsors. He is back, the professor. Matt Siembieda is also the father of Seton, went to Penn Law School and has practiced law for a few decades. And he is also a professor at Temple University School of Law. And we welcome back Matt. Hey, Matt, how are you?
Great. Thank you for having me. I look forward to it.
This is an interesting case that really needs legal eyes on it. Because a layperson, you're like, wow, what just happened here?
It was a really attending Tuesday was really interesting legally, I thought.
So to give you the basic premise of what's going on here, the retrial of the former Summerville jeweler Michael Colucci was supposed to begin on Monday, June, was that the 16th?
16th, I think.
Okay. He was charged with the 2015 murder of his 38-year-old wife, Sara Lynn Colucci. The last episode you can check, we talked all about this. He was first tried in 2018. That trial ended in a hung jury. He was unanimously cleared for murder, but the jury could not reach an agreement on manslaughter. Now, again, let's think about that. That's a decade since the death of Sara Colucci. And because of COVID and other delays, the retrial took a little while. Again, remember 2018 was the hung jury, so we're 6-7 years later, it happens. So,
and I heard somewhere that I think it was the oldest murder trial left in our state.
Yes, I did see that too. You're right. I think Post and Courier had talked about that. The story goes in 2015, Michael Colucci called 911, 7:13 at night, and said that his wife had tried to hang herself with a garden hose that was hung from a 6-foot tall chain link fence at a warehouse. They operated the Gold Standard, it was called, in Summerville, South Carolina. So you can go back and listen to that. So there were some injury and some marks on his body, some marks on her body. It took
a fat lip, which he says he got administering CPR.
Yes, and it took them, what was it, a year, I think, or 2 years before they actually tried him. It was a year before they actually arrested him, and then another year after that for the first trial. And then that took about a year. So that brings you up to date on, and again, if you want the details on what happened in that last trial, you can go to our previous podcast episode. So Monday, Seton, you go down to the courthouse and talk to us about, it was actually the Friday before the start. The defense had filed a motion to dismiss for government misconduct pursuant to Brady versus Maryland. So you went down there on Monday. What did the motion say and what was going on?
Well, this was a pretty big bombshell motion that was filed just, on the eve of the trial beginning. And the defense contended that the government had been in possession of exculpatory materials regarding Sara Lynn Colucci's plan to commit suicide by hanging. Yet it was never disclosed to the defense that the prosecution had direct knowledge of it until now. And again, this is just days before the trial was set to begin.
Mr. Matt, Professor, explain the basics of Brady.
Sure. Brady was a Supreme Court case. It was Brady versus Maryland in 1963. There have been some other cases afterwards which support and better and explain or expand Brady to some extent. What Brady basically says is that a violation occurs when the prosecution fails to disclose what they call, as you said, exculpatory evidence to the defense in a criminal case. Now, what is exculpatory evidence? Well, this is evidence which could be material to the defendant's guilt or punishment. It is also evidence which may be favorable to the accused and may include information that undermines the prosecution case or supports the defendant's innocence. The Brady Rule was established, as I said, by the Supreme Court in 1963 in the Brady case, and mandates this disclosure be made even if the defense doesn't specifically request or ask for it. Now, the duty is breached regardless of whether the information is withheld intentionally or unintentionally. Now, as we know here, the judge made some findings, which I'm sure we're going to get to a little bit later in the podcast. And one of those was that the lawyers for the prosecution didn't intentionally withhold the information, but rather a state actor, the state investigator, had the information and didn't make it available, which is important. Now, a Brady violation, as I said, occurs when the state fails to provide this evidence or impeachment evidence. Impeachment means that you may be able to use the evidence to question a witness and explain why the witness is wrong. And this can lead to some very serious consequences for a criminal case. So let's talk just for a moment or two about what that means. It could mean, in a normal case, a mistrial. Now, we know here it hadn't quite got the trial. It could result in the judge suppressing certain evidence that the prosecution or state has. It could result in a full dismissal of the charges with or without prejudice, which is what occurred here, as we're going to be talking about. It could overturn a conviction that may have happened. It could result in disciplinary actions against the prosecution and others as a result of this conduct. And I know you're going to talk about it a little bit later, but there certainly was a reaction afterwards by the state attorney general's office in a press release with regard to that. Here, the judge basically sent it back to the beginning, namely said that it had to go back for the grand jury with full evidence or transparency as to what took place here, which is another alternative. Now, it's in terms of a burden, who has to show this, that this was material exculpatory evidence? Well, it's the duty of the defendants to prove that any withheld information was both material and favorable to them. That's sort of an important issue to keep in mind here. And that's why the defense, I'm sure, as we're going to be talking about, sent out subpoenas and conducted a full hearing before the judge on the 17th of June this year. And I'll stop there.
A quick note, real quick. People may have heard Brady recently because Alec Baldwin, the Rust case, also used Brady. The prosecution was withholding things from Alec Baldwin's defense team. And one other thing, just in general, back in the day before the computers, when I've heard stories about, because you have to turn everything over, the state of the prosecution could pull up like a U-Haul truck full of boxes and paperwork and just overwhelm the defense, right? But computerized now, it's a little bit harder to do that. But wasn't that like at times a tactic?
Yeah, I mean, I've experienced that directly myself.
Oh, really?
Where someone dumps a huge box of materials on you, and it's your obligation the last minute, usually it's the day before, to testify, to dig through that information and find it. That happened to me in a case in Phoenix, Arizona, and I was able the night before, by staying up most of the night, to find this evidence buried in these large files and used it to cross-examine a witness the next day that resulted in us winning the case. But you're right. That's the way it used to work. The other important point here is that I'm not suggesting that it's on a regular basis the government withholds information, but certainly more and more we're seeing now, particularly in the digital age and the age of social media, where this information is coming out that, I'm not saying in a lot of cases, but in some cases like the Alec Baldwin case, in this case we're going to be talking about here, that it does occur. And therefore, I think that it's incumbent upon everybody, including the media, the press, the defendant, and the counsel, to continue to, search out the truth in these cases.
Okay, well, all right, we're going to go into exactly who was called and all the testimony that was within this hearing that was held before the jury was brought in with this motion to dismiss that was filed by the state. But let me just set the stage. So this motion was filed on a Friday, and then the jury is set to come on Monday to be selected. So Monday was jury selection. A jury was selected, and before the jury was brought in, we're going to hear this motion to dismiss. Were you surprised that the jury was selected before the motion to dismiss was heard?
It depends. The way you just expressed it, it does sound a little bit unusual that the judge would select the jury before he heard the motion and decided it. The thing that I don't know is in this particular county, or maybe even in South Carolina generally, is there a limitation in terms of when jurors are called in time limits? So, for example, in some states, they call juries the second Monday of each month, and they're only there for 24 hours by law. So maybe there was a requirement on the judge's part to select a jury the first thing that Monday morning, and then move forward with any other motions thereafter.
Well,
I
and it
just
might
don't
have been
know.
hard. It might have been hard for them to get in. This was a Friday, and they were set to come back on Monday. So it may have even been difficult to reach all these jurors at that point and say, hey, come on Tuesday instead.
And another excellent point. And the other thing, I guess, is that, judges are quite busy. It's also possible that maybe the good judge here, because of the late filing of this motion and the need to select a jury promptly, didn't really have the chance to fully review the motion until sometime after the jury was selected.
The defense first called Barbara Moore, the mother of Sarah, the victim, maybe victim. So, Seton, what did she say?
Well, she testified about this incident that happened approximately 2 weeks prior to Sarah's death. According to Miss Moore, she went over to Sarah's home where she found her in her garage that they had converted into a den. And she said that she was very upset. She was crying. Her eyes were puffy. And she puts her arms around her daughter and asked, "What's the matter?" And Sarah responded that she wouldn't understand and that, quote, "If it had not been for her children coming home today, I would have hung myself in this garage," end quote. However, then Sarah does tell her mother that she wouldn't do that to her, I guess killing herself, and that she would definitely not do that to her children. Now, Miss Moore is concerned about her daughter. She offers to take her to the hospital, get her some help, even pay for it because she's scared about her emotional state.
Miss Moore says that she told SLED investigator David Owen this information when she was interviewed in August after Sarah's death in May. This was 2015. Now, David Owen, you may recognize that name from the Murdaugh trial. He was the officer who testified in front of the grand jury that there was DNA or blood evidence on Alec Murdaugh's shirt. Well, that turned out to be inaccurate, and that was a sticking point in the Murdaugh trial a little bit. So David Owen has had at least twice a little history of this.
Right. Someone put on our Facebook page 3 times. I'm not sure what the third time is. I asked the person, so I'm not sure, but at
Well,
least
I kind of figure if somebody doesn't only do it once or twice.
well,
I'm not saying
it could just
in
be
general, people don't just do it
well,
once or
people
twice.
make mistakes too. But so Miss Moore then is shown a clip.
Can I just add one
Yeah.
point
Yeah.
to that? In states generally they have a Brady list. And what is a Brady list? A Brady list is a list of law enforcement or state actors who are law enforcement investigators and others, and policemen in various large cities and that, who continually create these violations.
Gotcha.
And that becomes very important because that'll affect how the state may proceed. It could be used by the defense to impeach witnesses and stuff like this. And I'm not suggesting that Mr. Owens, who I understand received some awards when he retired, is on such a list, or South Carolina even has such a list. But that would be an interesting thing to know.
Well, Owen's not with SLED anymore. We talk about that later, but I can't imagine anybody would ever want him to be testifying again.
He's definitely after this for sure. There's credibility issues. But so what happens next is Miss Moore is shown a clip of her testimony during the first trial. Now she's being questioned by lead prosecutor Megan Burleson, and during this clip, Miss Moore says, "quote She cried until her face was swollen. I said, 'Oh my gosh, honey, what's the matter?' She was sitting in a chair." Now, at this point, the prosecutor interrupts Miss Moore and says, "Let's not say anything, okay? Just describe how she's acting. Did she appear upset or happy?" And I guess the implication is that the prosecution did not want Miss Moore to testify about Sarah's statements about hanging
So it
herself.
felt like they were stopping her.
It felt like
saying that.
it felt like they were stopping her. I guess this is what the defense is contending is that, why did you stop this testimony there? So
On cross, then, on this trial, Miss Moore testified that she did not put the hanging statement in her written statement that she gave to Agent Owen. Miss Moore does not say that she was told not to put the information in her statement.
right. So she's not saying that anybody from SLED or the AG's office said, "Hey, don't put this information about this statement your daughter made about hanging herself."
Also, Miss Moore does state that she did have a friend who watched Perry Mason and told her that you can't say what someone else says because that is hearsay. So she's saying that maybe she didn't do it maybe because she had learned about law through Perry Mason.
She said her friend said you can't testify to hearsay.
Miss Moore did not indicate that she ever told anyone with the AG office about the hanging conversation. So your takeaways from that, Mr. Matt?
Miss Moore's testimony.
Yeah, I mean, it's certainly at a minimum very unusual what she did here, and that's at best. The defendants have a duty to object the way our court system operates if hearsay or other inappropriate information is coming on.
So it's not usually the prosecutor who would make that decision. It would be an objection from the state.
Yes.
Or for the defense.
So like
Yeah,
the prosecutor in this case is saying she didn't continue with that questioning because she felt it would be hearsay, and the judge is telling her, well, that's not your call to make.
Yeah, because the suggestion, which I think probably the defense used fairly effectively at this hearing, was that the prosecutor was trying to withhold evidence by cutting the witness off in sort of a clumsy way, using an objection which really should have been made by the defense.
Yeah, she's objecting to her own witness.
Because don't you just try to get in when it's your witness? Don't you just try to get in as much as you can and hope that someone doesn't object if it's a hearsay thing?
Listen, as an old-time trial lawyer, I'll tell you that many times I have, and I've seen others, try to get in evidence as much as they can until someone objects and the judge rules. You're almost required to do that in a certain way, whether it's hearsay evidence, whether it's leading witnesses. There's a whole number of things that lawyers do to make it more jury friendly so the jurors can better understand the case and hear it and see it and understand what's going on. Also with regard to the hearsay objection, there are certain other exceptions to that even which could have been made. So for example,
Excited utterance.
yeah, well, so for example, so-and-so said this to me and that affected my state of mind. So if you can argue that if it affects your state of mind, you're not going to the truth of the statement. It's just what you believed. And so there's a whole bunch of other reasons why her doing what she did in such a clumsy way was inappropriate.
Well, what does it factor into hearsay, the fact that the person who told this information, Sarah, to her mother is no longer with us and can't relay that information anymore? Does that play into hearsay at all, or it doesn't matter?
Well, there's all sorts of rules dealing with dying declarations of people, and which obviously she wasn't dying when she said that. And there's, other information there. Clearly, this information was probative for the reasons I said at a minimum. It certainly created in the eyes of Ms. Moore, a belief, a state of mind that her daughter was suggesting or threatening to commit suicide in some way. So I think that that certainly would have been probative and been admissible by a court of law, and it should have been admissible here. The other thing is that there was obviously some notes and other information that were taken at the time this was all done, as investigators normally do, and for some reason those notes or messages no longer appear or didn't appear. It was simply the recollection of Ms. Moore, I guess, that brought this to light.
I have a question. I just thought of this though. Let's say the prosecution or the defense had known about what she was saying. Just to play this for a second. And you are the prosecution and you're interviewing a witness and you see that the witness is going to go to a place you really don't want her to go or him to go, you might, as long as the defense knows it, you can kind of cut them off, can't you? Have you done that with witnesses? You saw,
Mhm.
even though they're your witness, you just see them going in a place you don't want them to go.
Yes, that's correct. And so, it's not totally on the prosecution. Maybe it was a tactic to cut the witness off. You're correct, but it was certainly unusual, and so it created the impression with the judge in this case, I'm sure, that
Hiding.
it was possible that the prosecuting attorney was trying to withhold information from the jury.
Yeah.
But you're right, it's not unusual for someone to use it in the reverse way also to try to keep information out that would hurt their case. You're correct
But
about
as long as the defense knows it, they're not hiding anything. They just are.
Yeah, that's the real
defense
issue.
draw it out. Yeah. Yes. Next, we got who do we hear from?
We hear from Matt Ellis, who is an investigator with the Attorney General's office. He's been there since 2012. And from what I could tell, his job is to document new information and memorialize it. I guess he does memos. And there were a lot of questions about his note taking and documentation. He said that he typically shreds and deletes notes after memorializing any new information. And he states that he did not have any additional notes from his meetings with Barbara Moore. But he does say that in February of 2023, in a memorandum, he did document Sara saying that she would hang herself if not for her children. So the defense did have this information about Sara making these comments to her mother in 2023.
Okay.
So, Dad, there's lots of talk about shredding stuff. That seemed, like, I don't know, I guess maybe the idea that why aren't they keeping all the notes? What do you make of this? And also the fact that the defense has had this information since February of 2023.
Well, a couple things. With regard to the defense having it since 2023, they should have acted upon it sooner. And if they had this information and stuff available, they shouldn't have done it on the eve of trial. I understand trial lawyers are busy. A lot of things are going on in their lives and other cases and stuff like this. But this is something they should have done earlier.
Well,
Now,
let me ask you a quick question. I don't mean to interrupt, but if they had it, doesn't mean they necessarily saw it, right?
right.
So is
But it
that
was in their possession. They have a duty to
okay?
look to see what they got.
Gotcha.
Now, with that said, so long as you raise it before the trial starts, it's appropriate, and that's what they did here. So they're okay the way they did it, but I would have thought they probably should have done it earlier, since they had it available to them. But particularly since their client was under so much duress and pressure of a trial coming up for another year and a half or 2 years after this information was made available to them. But with that said, it's they did raise it before the trial, and that's appropriate. With regard to the shredding, that there, I don't know what the rules are in the Attorney General's office, or in SLED or enforcement or whatever with regard to these things. But if they have a regular business practice of a reasonable business practice of shredding and destroying evidence, companies and others do that all the time. There's nothing per se wrong with that. I think in a criminal case, though, where this information is available, it's obviously important. It obviously goes to the heart of the case in a number of ways. I think there should be an obligation on the state to retain this information.
No, he's saying that, he just takes these notes, but if there's anything new, that's his job, anything new that he's going to put it in a memorandum. He's going to memorialize it. So I guess maybe, thinking those are just his chicken scratch notes, and maybe he thinks that, but it's just unusual that you'd be shredding so many things.
Well, especially in a murder trial, right? I mean, we're talking about somebody's life here. Let's keep every stitch of paper we have so there's no questions.
That's my point. I mean, I mean, I can understand the concept that if you prepare something that has point one, and then later on you discover point two in a case, you say, okay, I'll get rid of point one, but I'll put point one and point two in a new memo. I understand that, but I think in a serious criminal case like this, you ought to keep everything.
Yeah.
Gotcha.
And for your own protection, even. And
Yes.
just, yeah, right. So there's, you can't get questioned on it. Let's see, where are we now? Oh, the attorney, right?
Yes.
The attorney. This was interesting.
Prosecutor from the first.
Yeah, the former prosecutor who's not in that office anymore,
No.
Megan Burleson, was there under subpoena. See, I remember talking to you and you were telling me, boy, she came in hot.
Yeah, oh my gosh. She was hot. Her whole demeanor was angry. She pretty much stomped down the aisle. And she immediately gets on the stand. She asks the defense attorney to tell him his name, and he says no. And there's kind of this back and forth between the two of them. And he's saying, I'm sorry that I brought you here in the last minute under subpoena. And she says, I think you probably knew that for quite some time that you needed my testimony. She's very hot and kind of confrontational.
When you say last minute, when did she get the subpoena?
I guess probably they filed the motion on Friday, so she probably got it Friday or Saturday. I don't know. They didn't exactly say, but not long. So she had only been in, possession of this. They only knew this hearing was going to be held a few days before. So she's mad, and she says, I think you've known that you had this. Probably she's referring back to the 2023 memo. You've known that you needed my testimony for some time, but the judge then stops her and warns her to stop editorializing and to answer the questions. And if she would not, she would be in contempt of court.
Wow.
He was mad.
I mean, I assume that she knows the rules, the idea.
She's an attorney.
She's had probably a couple days to cool off if she got it Friday or Saturday.
She was spicy.
Seems very personal, but that attitude, Professor Matt, what do you think about that?
Well, a couple things. One, the fact that she apparently acted inappropriate before the judge, and the judge scolded her and said he was going to hold her in contempt unless she conducted herself in a proper way. That plays right into the defendant's hands. So I'm sure the defense and their counsel was very happy that she acted that way. With regard to the subpoena, I mean, there's no reason for her to cooperate in accepting subpoenas. I mean, you can not answer the door and do other things. I would, if it was up to me. And I think the defense used it the right way, in that they basically explained to the judge that they went there to serve her. She didn't answer the door. They waited outside. She eventually came out and she was very crusty to them when they served her. I think all that plays nicely, into the defendant's hands, questioning the prosecutor, questioning what happened, questioning did she have any knowledge of withholding information, and puts the whole prosecution in a bad light the way she acted. And I think probably the defense sounds like they did a good job in creating that impression with the court.
Because it seems like she has something to hide. If you're not answering I'll take the subpoena. What do I got to hide? But instead, it's more like, I don't want to, right? I mean,
well, yeah. And in this case, since this was before the jury's brought in, the judge is the finder of fact. Is that accurate too? So he has to assess these people who are being called as witnesses and determine what he thinks as the finder of fact in this pretrial hearing. Is that accurate?
Well, at the trial, the jurors are the ones who decide.
But in a pretrial,
but on this motion, it was before the judge. The judge was supposed to decide the facts. You're correct, and decide who's right or wrong on this particular motion for which witnesses were called.
Now, she was shown the same clip that Miss Moore was shown about when she was testifying, and she cuts her off. And she's asked about this, and she says, "Well, it's my obligation not to allow improper testimony. I guess hearsay." What are your thoughts on that? Do you think the judge bought the fact that, I guess Megan's story was, it's her job. She's shown the same clip that Miss Moore was, where she's questioning Miss Moore and she cuts her off. She cuts her off. And she says the reason she did this was because it's her obligation not to allow improper testimony, which would be hearsay. So she says that's why she cut her off, and not because she had any knowledge of what she was going to say in regards to Sarah telling her that she would have hung herself if not for her children.
Yeah, well, it goes back to what we were saying a little earlier. I mean, it's unusual at best.
Yeah. Well, the
And
judge
you
didn't
know,
buy it.
yeah, yeah, and it gives the impression, and the defense used it the right way, that she was trying to withhold or hide information from getting to the jury and the judge at that particular time. And as I said before, any lawyer knows that it's the duty of the defense to object to hearsay evidence coming in. And as we talked about before, there are some exceptions, and there were probably exceptions here that would allow that information in any event.
Next, we got another question.
Oh, no. Next, we kind of talked about this a little bit, but it was kind of interesting. Like, I think that the defense got the exact response that they wanted from Miss Burleson.
Yeah.
Exactly.
And you mentioned you would if you were given a subpoena. And it seemed to me, being an officer of the court, you're a higher standard than Joe Schmo. You're supposed to respect the court more than the civilian. So I would think that accepting the subpoena should be almost understood. You don't avoid that.
Because next they call the
PI.
The PI, just to kind of, I think, honestly, like rub salt into the wound of what was happening. But tell us what the PI said.
The PI that was charged with serving Miss Burleson with a subpoena, as you said, he said Miss Burleson didn't answer the door, although it appeared she was home. He watched from down the block. About 10 minutes later, she comes out, at which time he parked next to her. And she kind of had nothing to do with him.
He says she's very, very angry. And she says to the guy, are you the guy who has been knocking on my door like a MFer? And she said the word. He said the word. So I guess she said that as an officer of the court, you're not under any sort of heightened obligation to accept legal service.
No, I mean, you're like a regular person on it. I think it's best practice to cooperate and do that, particularly if you're a lawyer and you're a member of the bar, to do it that way. But I mean, and I think the big takeaway from this is, from the defense point of view, it really plays into their hands, because here you have somebody who acted a little off, and very belligerent, and it creates the impression that this person is uncooperative and maybe trying to withhold or hide evidence.
Yeah.
So from the defense point of view, it plays right into their hands.
Yeah, I mean, it definitely does. It's definitely, it is. Why, if you, the response would be like, hey, subpoena me. I got nothing on. I didn't do anything wrong. But when you're doing it the other way around, not a good look.
That's exactly right, Matt, because, sure, thank you. I'll see you in court.
Yeah.
To say anything do other than that, and that's it. And you get on, and I guess as she testified, she was not aware of this information at the time she tried the case. And, she could have said that. And I know the judge ultimately found that there wasn't, evidence that she was aware of it. The judge was very kind to her the way he handled that and did all that, which is fine. But I mean, she ran a huge risk the way she handled this, because the judge, could have decided that she herself had withheld information, which could have resulted in serious issues for her. And I think the judge, as in this case, acted the right way, looked at it. It wasn't clear, so he didn't find that she acted in the wrong way, but it certainly created a whole atmosphere, an environment around the case, the way she acted during the trial, the getting the subpoena and everything else, which didn't help the prosecution in any way.
Was there a pretty good chance?
She rolled her eyes when she was walking out after she took the stand and she was released. She looked at the state team, and she rolled her eyes like, oh, I can't believe I had to be here. I mean, that's how I took it. Yeah. She rolled her eyes. I don't know why she rolled her eyes, but that's how I took it.
Well, I would assume there's a pretty good chance that she knew the subpoena was coming, right? Within this small community, somebody say, hey, you gotta, it's not like the guy knocking on the door. Didn't know he was the flowers guy or bringing candy or she had to have been given a heads up why this dude was knocking on her door. Right? I mean, when you think,
I don't know. I mean, it's possible. I just don't know.
because like, why would she not,
Yeah.
pull over and get all
I
angry?
don't know. If someone's knocking loudly on my door, I might be
guess.
scared too.
I guess.
Like, I'm not answering.
Yeah,
If
that's
I
true.
think it's like a salesperson, I don't answer my
Yeah,
door.
that's true. But then pulling up to him and like, rah, rah. Okay, so that's true. We finally hear from former SLED agent David Owen, left SLED in June of 2024, received Agent of the Year before his departure from SLED. Seton, your takeaways.
Okay, so takeaways from him is that he says that he was not aware of the statement Sarah made to her mother back in 2015 when he initially interviewed Miss Moore, her mom. He says he did become aware of it at some point, but he can't tell us exactly when. He says it may have been during a phone conversation, which he doesn't always document. He said it could have actually been when he was driving, so maybe that's why. So he admits that he didn't document that specific information, but he does say that in the files there were other information about suicide, Sarah's suicidal thoughts, issues with drug and alcohol. I think there was information about from her psychologist or psychiatrist. I'm not sure which one. So there was and some text messages, some information that was in the file that showed that she had maybe talked about suicide and that sort of thing.
Can I ask you a question about that? He says he doesn't remember when it happened, but he's saying it did happen. He's admitting it. He recalls her saying it.
Calls her saying it, and
Okay.
he admits that he did not put this in a report, but he says he doesn't know this back in 2015. So I mean, there's a big issue that this is, 2015 is 10 years ago. He doesn't really say he can't tell us when he did become aware of the information.
When she told him.
Right, whether that was before the first trial or after
Before
the
the
trial.
grand jury or after the grand jury.
Well, no, he didn't tell the grand jury that for sure.
That's what I mean.
Oh, yeah, but he does. Yes.
He's not saying he knew it. He's not admitting to knowing it before he went to the grand jury.
Right. So, Dad, this does seem like this conversation that Sarah had with her mother, where she talks about hanging herself 2 weeks before her death. This may be asking the opposite, obvious, but does this constitute a Brady violation?
Yeah, I mean, um, certainly orally, but I think he probably should have documented this up at the time also. This was said. I remember this case was a case, as I understand it, where there were no eyewitnesses. It was simply the guy and his wife Sarah who died. And there was some circumstantial evidence around the site. I guess there was some sort of hose allegedly around her neck. There was a broken bracelet. It was a cut lip by him. There was some bruises and scrapes on his arm.
What could be drag marks, I believe.
Muddy shoes, things like
Yeah.
that.
Yeah. So all those things are circumstantial. And certainly it took the state a while. I mean, it took 3 years to get the first trial.
And even a year to arrest him.
Even a year to arrest him. So clearly the state was struggling to come up with a case that they were going to proceed with. And this information would have been very important to, in that consideration. If it was available and known, and certainly would have been very important to a grand jury and others as to how they should proceed. Particularly since the case, as I said, was based upon, all circumstantial evidence, and one might have, but for what was said to by the mom and what was said by Sarah to her mom and conveyed to Owens, but for that, the state might feel it has a lot of evidence based upon all the other circumstantial stuff there. Question is how would this affect it? And it sounds like it's fairly important. Particularly since the suggestion by the husband was she committed suicide.
Well, I have a question about the grand jury and how that works. The old saying is you can indict a ham sandwich, right? The rules are so much different in the grand jury.
Mm-hmm.
So when you're presenting in front of the grand jury, is it his responsibility to present everything? Or because it's not the same as a trial, right?
Mm-hmm.
So and the defense, you don't even have a defense, right? Or
Defense is not in the room. No,
okay.
it's only the prosecution.
So, you don't have to present everything. You just can't present fake stuff. So is it an obligation to say that part of it? You know what I'm trying to say? Like when you're doing it in front of the grand jury, how much do you have to tell?
Well, I think, if you're presenting evidence to a grand jury, and you have, for example, and may not be the case here, but if you had strong evidence that someone didn't commit a crime, you had an eyewitness or you had something else, you have a duty to disclose that to the grand jury or not move forward at all. So in this particular case, I would suggest that, that they did have an obligation to disclose to the jury that she had said to her mom that she felt like committing suicide. I think that was a very important thing to do. And I think, obviously that would have affected at least a consideration. And I realized that
she actually says she would not commit suicide because of her children. So she says the opposite.
If it wasn't for my kid.
She thought about it, but she says, no, in fact, I would never do that to my children or to you, my mom.
Just remind me of one thing, Seton. Did the mom tell that to the husband right after the conversation?
She says that she did tell this to her husband, but her husband is no longer with us. He passed away. I don't know when, maybe a year or two ago.
But she didn't tell it to Michael Colucci.
Oh, did she tell? You know what? That's unclear. She may have told Michael Colucci, and that's a good question. Did she tell Michael Colucci and put this thought in his head that, hey, well, she's already talking about suicide. I want to offer, and I'll just make it look like a suicide.
Exactly. And that's the reason why I asked the question. I thought there might have been something in the record about that.
I have to go back and look, but I think there is a good chance that he was aware of it. I mean,
maybe not from her, but he was aware of this.
She says she was there for a short period of time. Michael, the husband, comes home and, he says, I can calm her down. And Sara had asked for the mother to go pick up the children from school. So the mother leaves and picks the children up for school. And in fact, the children spent the night with her.
After this conversation.
After this conversation, Michael comes home. He sees that she's upset. I believe she was drinking. She's crying. Her face is all swollen. Her eyes are swollen. And Michael tells the mother, hey, I can calm her down. There's no need to take her to the hospital.
But that's implied that he would know that then.
Yeah,
maybe not specifically hanging, but he would know.
He would know that she was upset, so much so that the mother was offering to take her for medical attention and offered to pay for it because they were having financial problems. And the mother says she did not want Sara Lynn not to go because she couldn't afford to go. So she offered to pay.
So he had to be aware, yeah.
So he had to be aware.
Well, the question then is why didn't he convey this to his lawyers, and why didn't his lawyers use this at the first trial or earlier on, since it was known to them?
I think there was information in the first trial about her
with her psychiatrist or psychologist, but not the mother thing. There was mentions of her having these thoughts.
Right. And another thing that we should mention, this is 10 years ago. So people are trying to recall stuff that happened 10 years ago. I mean, I can't even remember what happened last week.
Right. And does this matter that, okay, so Michael Colucci is aware that she's having suicide thoughts?
Well, it would only if he was aware, the government was aware, which apparently he was not.
But is the hanging thing the important part? In other words, that could be like she might have said to Michael Colucci she's thinking of taking her own life, but left out that she's thinking about hanging, which is kind of important considering that's the way it happened.
Yeah, and it would create a better case for the government, obviously.
Okay.
So the judge takes over an hour, I think almost probably close to 2 hours to come back with his decision. And let's listen to what he had to say.
Madam Court Reporter.
Yes, sir.
All right. All right, well, I've considered this matter, and I want to make clear that when I speak of prosecutorial misconduct, I want to make certain that you understand that I'm not speaking of members of the prosecuting attorneys per se, but because of state actors for whom the state is responsible, under the case of Kyles versus Whitley. This case alleges that the husband of the deceased murdered her, and the defense claims that the deceased committed suicide in part because she was still emotionally distraught by the suicide of a previous husband. And the date of this incident was right around the anniversary date of that suicide. This was a very unusual and dramatic suicide, and it was known to family members that the deceased never got over it and had a very difficult time emotionally around the anniversary of that suicide. The critical issue in this case was that the deceased mother went to the deceased home several days before this incident and found the deceased in a very emotional state, and she told her mother that she wanted to kill herself by hanging. But she did not want to do that to her children, and the mother was so upset that she wanted to have her hospitalized. And after the deceased died in this case, the mother has now testified that she told the lead investigator about that incident within a few days. The lead investigator denies that she told him at that time, and he buttresses his story by pointing out the mother hand wrote out her statement, and she did not mention this prior statement or this prior incident in the written statement. Well, the defendant was indicted at the first trial, ending in a mistrial. The mother did not mention the prior incident at that trial because she was cut off by the prosecutor when she started to talk about what the deceased said. The prosecutor testified that she cut her off because of hearsay concerns. I note there was never any attempt by anyone to allow the mother to testify about the deceased statement under 8033 under our rules of evidence, so the court never ruled on it. But while it was known to all that the deceased suffered from severe drug and alcohol abuse and was being treated by a psychiatrist at the time of her death, evidence was presented at trial of the same. It's very troubling that the evidence that the deceased made specific threats of wanting to kill herself just days before she died. This information was kept from the jury. By state action or inaction, had the defendant been convicted, this court has no doubt it would have been considered a Brady violation, and the defendant would have been granted a new trial. The beginning of a new trial is exactly where we find ourselves today. The state argues with some authority and precedent that basically this court should treat it as the equivalent of no harm, no foul, and that now that this information is known, it can be presented to the jury, who can evaluate it and give it whatever weight it determines it deserves in arriving at a verdict. Indeed, this court believes that it is a choice among several that would no doubt be upheld on appeal if this trial were to go forward and the defendant was convicted. However, this court believes that our courts should demand better from the state, and to simply allow this trial to go forward with so many witnesses, such as pathologists, having been denied the opportunity to have this critical knowledge available to them when that material was fresh, amounts to a foul with a harm. Therefore, this court is quashing this indictment without prejudice and ordering that if the state wants to retry the defendant, it is to do so only after the case has been resubmitted to a grand jury who shall have the benefit of the full measure of evidence this matter deserves. This court recognizes this is an unusual remedy. However, this is an unusual case. And this court urges the Attorney General to present a fuller case to the grand jury than is usually done in state court in South Carolina. The goal is to do justice, and this case deserves a fresh restart in order that the citizens of South Carolina can have full confidence in whatever the jury's verdict may be. It is so ordered. All right?
And we had a statement from the AG, quote, yesterday in a court hearing regarding the case against Michael Colucci, Judge Roger Young quashed the indictment without prejudice, which means the state can reevaluate the case and remedy any issues addressed by the court's order before another trial. We respect the decision of the court and note that Judge Young did not find intentional misconduct by prosecutors with the Attorney General's office.
No. I was super impressed that the judge took such a long time to give this thought, because it seems to me in other trials that I've attended, maybe the judge already kind of has it in their head what they're going to rule on something. This judge really was considering everything. I mean, he took a long time to really evaluate what he thought the right thing to do was.
And you broke it down earlier about all the different things that could come from this. There's many different things, but just to readdress one thing again is with prejudice, without prejudice. Explain.
Well, with prejudice means they can never bring the case again. Without, it means they got to go back to square one, namely the grand jury, and start over again, and to be fully transparent and disclose, the fact that that Sarah had the conversation with her mother and how that may impact the grand jury going forward.
Now, the defense did argue. They said, "Hey, we think they argued to dismiss it with prejudice. They said this is such egregious behavior." So they argued for that, didn't get that. But they said, if you don't do this, we think that it needs to go back to a grand jury, which is ultimately what the judge decided. Why? And the state argued. The state said, hey, the remedy for a Brady violation is a new trial. Dad, why do you think the judge sent it back to the grand jury?
I think that the judge felt that it gave a way out for everybody. The judge didn't want to necessarily throw the case out altogether, is the way I read it. And that by saying that you got to start over again and establish that you have enough evidence to state a claim, notwithstanding the statements that were made by the mom, whether or not you want to proceed or not. And so the real question is does the state, want to run in a highly publicized case a risk that a jury now could turn them down? As Matt said, it's I don't want to say it's easy, but you can get people indicted fairly quickly based upon the way the system operates here. But because of what's going on here in a very public nature of it, and the fact that it's based upon so much circumstantial evidence, and we brought out some new stuff in our conversation today about the husband knowledge about her, contemplating suicide. And that may have played into his defense a little bit if he did do it. I'm not saying he did. That does the state want to move forward? And I think that if you look at the statement that Matt Harris read, you see that the state in its last sentence says basically that, hey, there's nothing saying that any of our attorneys acted in an inappropriate manner. They're all putting it on Owens. They're all putting it on the state actor, the law enforcement investigative side of it, rather than the prosecution side. So the state can basically take the position that, hey, we didn't screw up. The investigative side messed this case up. And based upon the way this case has gone, the fact that it's circumstantial, we're not going to proceed. So if you ask me what my view is, I don't think the state's going to proceed against him. It's possible, but I don't think so.
Well, we should mention, you have to feel really bad, seeing Michael Colucci's or Sarah's mother in the courtroom. It was very sad because in testimony she gave is one of the reasons why this case is being thrown out. But none of this is based on the evidence of the case. There could be really strong evidence, but none of it's based on the evidence of the case. This is based on the investigation and what was given or not given to the defense.
Although they didn't win the first time.
They didn't. Well, it was a hung jury the first go round. But, you feel bad because none of this, we're not arguing whether these drag marks or this.
Guilt or innocence, perhaps. No.
No, it has nothing to do with whether he was guilty or innocent. It has more to do with the evidence that was given over to the defense.
If they would, if they would,
The only suggestion I would make on that, I'm sorry to interrupt, Matt.
yeah, go
The
ahead.
only suggestion I'd make on that, Seton, is that it is important evidence as to what as to what Sarah's state of mind was.
Yeah.
And therefore, it was important evidence for that to be out there for the defense and for the jury to hear at the time of the trial.
That's fair. No, I absolutely agree with that 100%.
If they brought it up again, would Owen, like, would they even use him, or do they have to use him, or what would happen with him?
What's his credibility play into this?
Well, the defense would certainly call him.
All right, the state may not, right?
And they would, bleed it out. They would basically put him on the stand and go through in painful detail as to what happened when he interviewed Ms. Moore and how all that opened up and how all that transpired, and the fact that it wasn't brought out. And now maybe the way this is all evolved, it'd be interesting to see if his recollection is now refreshed, in terms of what his conversations were with the lawyers representing the state at the time. Because he's the one that's been thrown under the bus.
Well, he's been thrown under the bus twice.
Twice. So the question then is this: what does he do for his reputation? Does he, fall on the sword? Does he take the heat on it? And the defense is going to bring it out and bleed that out in the case. And it's going to be their way, if the case goes back to a jury and goes to trial again, for them to try to win the case. And they're going to claim everything else is basically circumstantial and whatever else. Now, Seton rightfully points out there is an awful lot of other important evidence out there. If you take that whole thing out, the whole conversation that poor Sarah had with her mom.
But you also have to think the state is ready to go. They had their big boxes of stuff. You saw them leaving with, their boxes of stuff. They were ready to try this case. So really, there's not a whole lot more effort that they need to put into they've got to take it back to a grand jury, but they were ready to start today.
Yeah, and the problem is, as I said, do they want to run the risk that either a grand jury or a judge or a jury down the line throws the whole case out based upon prosecutorial misconduct?
Now, let's say you had a client in jail right now for murder, we'll call it, and David Owen was the lead investigator on your client's conviction. Would you be looking into it? Does it matter? What do you think?
Yeah, like other cases that Owen's been involved in?
Yeah.
Like, or is his credibility going to be problematic for other cases that he may potentially be a witness to?
Or in the past?
Absolutely. I mean, there's a couple famous cases up here in the Philadelphia area where detectives in the Philadelphia Police Department basically, did all sorts of things with evidence that got people tried and convicted and put on death row. And all those cases are being overturned. So certainly the people would look into cases that Owens worked on, what he did, how he did it, particularly, if someone, for example, is on death row, it's got to be something you look at, particularly if you think you're innocent.
Right.
Well, what
right.
if Murdoch gets a new trial where they call David Owens?
Yeah. It's
Yeah, because it creates a whole little. I don't know if the judge would let it come in if the prosecution is not going to use any of that evidence, but it's a way for the defense, if they can get it in, to show how the state went overboard in trying to get him indicted and convicted.
Oh, wow.
Well, Judge Young, when he made his ruling, he tells Michael Colucci, you don't have any current pending charges with the state of South Carolina. You can get this ankle monitor off. And after the hearing, Michael Colucci did speak to the media outside of the courthouse, and he pulls up his pants leg and he shows, this ankle monitor that he says he's been wearing for 10 years. It's actually pretty big. I mean, I don't know, at least I would say, 3.5, 4. Yeah, it's big. And he says that he, is suffering from neuropathy for wearing this thing for 10 years. Do you think that Colucci may possibly file a lawsuit against the state of South Carolina?
Yeah, it's possible he could go after them for some wrongful prosecution. And, all the time, people who bring those cases end up settling out for a decent sum of money if they can establish that. Now, the one risk that he does run here, that if, and I'm not suggesting he did, but in fact, hypothetically, if he killed Sarah, if he goes forward with that case, it gives the state an opportunity then to question him, to get into more evidence, and maybe to try to show more of that. So he runs a risk if he does that.
Oh, because he would have
If
to
in
be
fact,
he would be deposed in the course of a civil litigation, and so they
yeah,
could ask some of these questions that because I don't think he did not take the stand in the first trial.
No.
He did not take the stand. So, but if he does pursue civil litigation, they would have the opportunity to depose him. Correct?
yeah. I mean, if he has any concerns now, yeah, I'm not suggesting he killed her, but it's a tell a little bit to see if he wants to proceed on this or not.
But
You
there could be a
know,
civil lawsuit from
Yeah.
the family of his wife.
Well, and one thing that they could do, he could be waiting to see if uh, the state decides to present this to a grand jury or not. And it might be a little bit more convincing for his case if it's presented to a grand jury and the grand jury says, nope, not enough, not enough to have him,
Forward.
to indict him on these murder charges, then that would also maybe possibly bolster a civil claim.
Or Sarah's
by
family's
him.
claim.
But there's another claim too that Matt's talking about, and that is like in the O.J. Simpson case.
Mhm.
O.J. Simpson won that famous criminal case out in California. And then the Goldman family, the young man who was killed, brought a civil action.
Oh, yeah.
His
Yeah,
family.
you covered a big judgment against O.J. Simpson on that particular case. And for years, I don't know how successful they ever were, but they were chasing him around trying to collect on it.
Yeah.
And so there is the possibility that Sarah's family could try to bring some sort of action against him, also not just him bringing an action against the state. So it'd be interesting to see how, if at all, that all proceeds. I mean, sometimes people just want to move on with their lives. They don't want to on either side, whether it's Michael or whether it's Sarah's
family.
mom.
Yeah.
Yeah, they just might not want to deal with it anymore.
Do they
But-
have to wait on the civil lawsuit until they find out whether they're going to charge Colucci again or no?
No.
They can just
No.
move now. Okay.
Yeah, I mean, there could be some questions about is the case is a statute of limitations, did you wait too long, or newly discovered evidence and new information or whatever else, but they could proceed.
I thought, or I could be wrong, I thought there was pending civil litigation.
I thought there was two, but I thought they weren't allowed to or something yet because
Right,
there's already
because
a
they
trial
they
and
have
trial
to
coming up.
they have to proceed with the criminal first because
Yeah. Yes.
how does that work, Dad? Usually you have to do the criminal case before you do a civil case.
Yes, yeah, and remember the burden to win a civil case is a lot lower than to win a criminal case too.
Right. Right. Yeah. Yes. So I'm trying to think. I thought a note. I'm pretty sure they were going to do a civil lawsuit, but they were told you have to wait until the criminal trials are done. So yeah, they might be doing that soon. We don't know, but it's also been a lot of years now. So there you go. We're always grateful you're hanging out with us, everybody. And you can go to Impact of Influence on Facebook. You can also hit us up on the YouTube channel. Please subscribe to that. I did have a couple of comments for you, Seton.
Oh gosh.
But don't worry because they're actually pretty good. Aaron says, love you too. You do a wonderful job on your podcast. And also, thanks for giving Gigi of Pretty Lies and Alibis out a shout out the other day. Of course. And then I think I had one more that says, one of my favorite guests you've ever had is the lady who talked about, or I think it was a guy actually, who talked about the regional dialect and stuff like that.
I know, I loved
Yeah,
that one too.
Yeah. So
We
a couple of comments.
Oh, I also wanted to give a shout out to one of our listeners who works at the courthouse, and we were trying to meet up during
house down in Summerville.
in
mean,
Berkeley County.
Berkeley County, yeah.
Yes, But we were trying to meet up, and it was such a crazy day. And I thought that they were going back in session because the judge said it's only going to be 20 minutes, and then it was close to 2 hours. So we somehow missed each other, but maybe we'll get another case down in Berkeley County that we can cover. So I was sad that we didn't get to meet her, but we were so hungry by that point that I had to because I think it was like 3 o'clock or so by the time the judge came back, and we were outside listening to Michael, and I was like, I think I haven't eaten anything today.
So you went straight to the bar.
No, I did not.
Your dad's.
I went straight to Bojangles.
There you go. Support our sponsors, part of the Evergreen Podcast Company. Quince is one of them. I'm wearing Quince shorts as we speak. And we will talk soon, friend.
Your golf shorts came in, huh?
Yes, they did. Looking good. Thanks, Mr. Matt. Appreciate it, man.
Well, thank you. In this case, we'll have some legs on it too, at least to see what happens civilly and criminally going forward.
Yeah. Thank you, sir.
Thank you.
Thank
I
you.
appreciate it.
Thank you.